State of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on the Zoom? Say something if you hear it this time.
Yes, Your Honor. Javar Grayson.
The video opens with immediate tension as the court session begins inside the 36th District Court. The judge calls the case of Javar Grayson versus Police Officer Brian Ambrose. Before long, it becomes clear that this is not a routine procedural matter. Grayson, representing himself, has filed for a default judgment while simultaneously arguing that the court lacks jurisdiction over him. The judge quickly identifies the contradiction, questioning why someone who believes the court has no authority would file motions within it. The courtroom dynamic shifts as the judge presses for a direct explanation.
To you,
Good morning.
Well. All right, I see that there is the, let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You're telling me that the court doesn't have jurisdiction, and you're not sitting into the jurisdiction of the court. And why are you filing something in this court if you believe the court doesn't have jurisdiction?
Focus turns to Grayson's request for a default judgment. He argues that documents were submitted asserting his status and claiming lack of jurisdiction over him. However, the judge carefully explains what a default actually is, a failure by the opposing party to respond within the legally required time frame. Since the defense filed a motion to dismiss within the proper period, there is no procedural basis for default. The judge methodically walks through the timeline, clarifying that the defendant responded appropriately and that neither party is in default.
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yeah, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who is representing this police officer filed its motion back in June, dismiss in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss.
The defense attorney outlines why the case should be dismissed. He explains that the lawsuit appears to stem from a traffic stop that is already being handled in another courtroom. He further argues that the complaint fails to state a legally recognizable claim and that governmental immunity protects the officer from liability under these circumstances. The attorney characterizes the filing as an improper collateral attack on an ongoing traffic matter. The judge listens carefully before turning back to the plaintiff for clarification.
Failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. That's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. No, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file, strike that, if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is some type of traffic ticket. It started off Brian Ambrosius stopping me, and I believe I had the right to travel. It started.
When asked directly what the case is about, Grayson explains that it began with a traffic stop and centers on what he describes as his right to travel. He maintains that the district court handling his traffic case lacks jurisdiction over him and states that he brought the issue into civil court under what he calls common law. The judge attempts to narrow the issue, asking for a clearly defined cause of action, meaning a recognized legal claim supported by statute or precedent.
The default judgment, what do you that you are saying, and what is pertaining to. We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's actions being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michael, you get the last word on your motion.
Right, yes, very briefly, there was nothing filed by plaintiffs And it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing my right to.
After hearing both sides, the judge delivers a structured ruling. He first formally denies the request for default judgment, explaining again that procedural requirements were met by the defense. He then addresses the motion to dismiss. The judge states that the complaint does not establish a legally recognized cause of action under Michigan law. While acknowledging that individuals have rights, he explains that law enforcement officers are authorized under state law to conduct traffic stops. Because the complaint lacks legal grounding, the case is dismissed without prejudice, meaning it could be refiled if a valid legal claim is properly
I got it. All right, that you failed the state of action upon which the court can grant relief. This case and the complaint in this matter be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized under Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law, or done under color of law, but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular file. Good day to both sides.
The judge concludes the matter by clarifying that the dismissal is final for this specific filing. He advises that if the plaintiff can identify legitimate legal authority supporting his position, such as constitutional violations or unlawful conduct, he may pursue relief in the appropriate court. With that, the case is closed. The plaintiff's request for default is denied, and the defense's motion to dismiss is granted. The session ends with the judge wishing both sides well, bringing the courtroom exchange to a formal close.